Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina and today's topic, are UDAPs protecting consumers or promoting chaos? Exposing the fault lines under state statutes prohibiting unfair and deceptive acts and practices. Every U.S. state has its own consumer protection legislation, commonly referred to as unfair or deceptive acts or practices, or UDAP statutes. These statutes are a powerful tool both for private plaintiffs and state attorneys general, intended to redress marketplace misconduct and abuse of consumers. In this episode, we explore the common sources of tension and issues both among states' UDAP statutes, but also federal and state antitrust laws. Joining me today is my co-host, Alicia Downey. Hi, Alicia.
Hi, Christina.
So what are we talking about today?
Christina, many UDAP laws are modeled specifically on Section 5 of the FTC Act, which prohibits, quote, unfair or deceptive acts or practices, close quote. But their scope and the remedies that these state laws afford are much broader than Section 5. In cases involving anti-competitive conduct in particular, UDAP claims can succeed where antitrust claims under federal law might fail. In recent years, UDAP laws have been a source of some controversy and the target of legislative amendments. These efforts are a response to the ever-increasing volume of private litigation, including class actions alleging UDAP violations. Some of these cases involve high stakes for corporate defendants, as many UDAP statutes allow prevailing plaintiffs to collect treble damages and attorney's fees.
Who do we have as our guest today?
Today's guest is Matt Sawchak, a former Solicitor General for the state of North Carolina, who's now in private practice in Raleigh. Matt has represented clients in many UDAP cases and written extensively about state UDAP laws in scholarly publications, including the 2017 UDAP Symposium published in the section's own Antitrust Law Journal, which Matt co-edited. We'll ask Matt where the UDAP debate stands now and where the law in this area is heading. So welcome to Matt Sawchak.
Thanks so much for having me.
Some background for listeners into your biography. You're currently a litigation partner at Robinson Bradshaw in Raleigh, North Carolina, where you focus on antitrust and other regulatory litigation and appeals. You are currently the chair of the editorial board of the Antitrust Law Journal, an elected member of the American Law Institute, a fellow of the American Academy of Appellate Lawyers. And as if that weren't enough, Matt is also a graduate of Harvard and Duke University Law School, where he received both the JD and LLM. So, Matt, why don't you tell us what exactly are UDAPs? Where did they come from?
So, Alicia, as you said, the story of UDAPs is good to start by talking about Section 5 of the FTC Act. The FTC Act, as we all know, has been on the books since 1914. At its inception, it didn't bar unfair and deceptive acts and practices. It barred only unfair methods of competition. It was only in 1938, with the Wheeler-Lee amendments, that Section 5 was amended to extend to non-competition-related wrongs. Some years after that, starting in the 1960s, the FTC pushed the state governments, state legislatures, and the like, to enact their own laws that would act in parallel with Section 5 to pursue some of the same objectives, both through attorney general litigation and through private litigation, as we'll talk about. And all the states over about a 10-year period accepted that invitation. And now all of the state UDAP laws allow some form of a private right of action to enforce those laws. You know, what's notable about the modern history of these UDAP statutes is empirical studies, and some of these are in the 2017 symposium you mentioned, show that there's been about a 45% increase in UDAP litigation, mainly private litigation, since the year 2000. Another interesting feature of that symposium is Josh Wright and others have done survey-type reviews of UDAP litigation by submitting some litigated fact patterns to so-called shadow panels of economists with FTC backgrounds saying, would the FTC ever really charge this under Section 5? And have found that quite a few of those fact patterns that find their way into private UDAP litigation are not ones that the FTC would pursue. So that's where we find ourselves today, is where UDAP litigation has really extended a long, long way beyond Section 5.
And I think that having looked at the Antitrust Law Journal issue in which those articles are collected, there's very much a live debate over the cost-benefit analysis of UDAP litigation. Can you just sum up, who is pushing for what at this point?
Yeah, I think that's right. I think what sparks the debate is partly just the proliferation of these cases, as I said, citing that 45% statistic. But I think what stands behind that statistic is greater realization in the private bar that these statutes can offer what I call more for less, that the remedies you can get under a UDAP statute are often a lot more powerful than you can get under any other kind of claim you might bring, whereas the level of proof required and the rigor of proof required might be quite a bit relaxed from what you would see in an antitrust context or what would you see in a business tort context. The way the debate often plays out is, almost a classic plaintiff side, defendant side policy debate. And the defenders of broader UDAP enforcement often cite some of these formative fact patterns that the FTC was mentioning in the 60s and 70s, where you have elderly people who are scammed in some home repair matter or something like that. And if you focus on that kind of a plaintiff, you say, wow, that statute really accomplishes something because it allows her to sidestep the strictures of common law fraud and claims like that, and also has a deterrent effect on defendants we would all agree are bad actors. Whereas what the defendant side tends to focus on more is multi-state class actions under the law of 35 single state classes, all brought together probably through an MDL. Defendants would say this is entirely lawyer-driven, entirely opportunistic, serious manageability problems for the courts, and arguing, look, we need to be cutting back on the scope and remedies of these statutes. This whole thing has really jumped the shark. And in a lot of ways, the two sides are talking past each other.
Have you noticed any shift in the nature of the claims being made? I mean, I could see, with the advent of the internet, that there are more opportunities to scam individuals, and that may be driving some of the increase in cases. Are you seeing that, or do you think it's sort of still the elderly kind of fooled by the repairman gig that's being litigated?
Well, I can think of a couple of common forms of sort of mass UDAP litigation that you probably didn't see very much of 25 years ago. One is sort of an extension of false advertising theories, where you will see products like some years ago, Palm Wonderful, private plaintiff, this was of course subject of an FTC case as well, but private plaintiffs might take a product like that, look at the label, leaving Palm Wonderful aside, and say, this says cherry popsicle, and in fact, there is no cherry material in the popsicle. Give me treble damages and attorney fees. And by the way, there's 7 million popsicle consumers. So that's an example where you get these enormous amalgamations of plaintiffs based on very thin claims with, just a single class rep and probably a fairly lawyer-driven structure. Also extension of privacy concepts. whether there be a data breach or not, there's so many privacy issues that arise through our use of the internet. And almost any one of those could be said, any problem in that area could be said to violate the conduct standards under a UDAP statute. And there's probably no categorical bar to going after those problems through a private right of action under a UDAP statute. So those are two examples.
Now, I'm also interested in the use of UDAP laws in disputes between businesses. I'm in Massachusetts, which has Chapter 93A, which basically makes an appearance in nearly every private lawsuit between businesses, almost regardless of the subject matter. But particularly in the area where the UDAP law might supply an antitrust-like cause of action between competitors or to parties in a vertical relationship, say a terminated distributor or something. Do you think that that has increased, or is that just kind of humming along in the background? Not every state, I understand, allows business-to-business claims under their UDAP laws, but in the states that do, I think they're frequently deployed.
Yeah, no, I think that's right. In the states where a business-to-business claim is possible as a matter of doctrine, there's probably two ways it plays out. One way is the UDAP claim being tacked on at the end of a complaint that otherwise is pursuing some other predicate cause of action. And depending on how experienced and sort of thoughtful the pleader is, you might or might not see some description of the connection between the earlier claims in the complaint and the UDAP claim. But, the person who's really thinking it through may well allege that a violation of Section 1 of the Sherman Act or a violation of the Lanham Act or, a business tort amounts to a per se violation of the UDAP statute. No incremental proof required. We just translate it into a UDAP violation, do not pass go, do not collect $200, straight to those enhanced remedies. Another form of that strategy that you sometimes see is just sort of the chaos theory of pursue the UDAP claim only, in which case, depending on the conduct standard under state law, the defendant might literally have no doctrine to grab onto, that the conduct standard in the majority of states is just sort of this list of adjectives governing unfairness. And literally, it might just be a question, the only path of defense for the defendant might be to attack causation or injury, but nothing related to the conduct itself. So, Alicia, to your question, in these business versus business cases, you have those two pathways, and either one of them can put the defendant in a pretty disadvantaged position.
Can you talk a little bit about the different models out there and whether amongst the ones with the broader standard there is, again, sort of a subset of different standards within them? Do courts look at unfairness that much differently, state to state?
Pretty differently. Over half the states have got some listing of specific acts that are seen as violations of the UDAP statute. But often there is also a residual category saying anything else that qualifies as unfair or deceptive. But you've got quite a few states, North Carolina is one, that have almost exactly the language of Section 5 of the FTC Act. In either situation, one of the most challenging questions is what violates that broader prohibition. This is important partly because of the way that state law has diverged from federal law. Section 5 of the FTC Act underwent somewhat of a revolution during the Reagan administration. In 1980, the FTC put out a policy statement on unfairness. In 1983, it put out a policy statement on deception. Both of those policy statements ended up cutting back a good bit on the scope of Section 5 enforcement, at least in non-competition law areas. And in fact, the unfairness statement was codified in the 90s as Section 5N of the FTC Act. The pre-existing standard under federal law for violation of Section 5 for unfairness is what's called the cigarette rule from a rulemaking in the 1960s. And it really is just a list of adjectives: oppressive, or substantially injurious to consumers, or something like a court of equity would consider unfair, et cetera, quite open-ended standards. By far the majority of states where unfairness is concerned still apply that kind of adjectival test, which is pretty tough for courts to apply in sort of a predictable way.
And are there any particular states that stand out to you as ones that have really pushed the envelope in terms of what their courts have been willing to characterize as violations?
Well, I mean, my own state, North Carolina, is probably among the more wide open states in terms of Section 75 1.1 in North Carolina, which is the little FTC Act. It is the language of Section 5. North Carolina allows business-to-business recovery, which has led to a pretty high volume of litigation under that statute here. There are several federal court opinions saying that that statute here, the Section 5 analog, is something you can expect to see in essentially every piece of business litigation that there is. Also, it's pretty aggressive in the sense of remedies. North Carolina allows automatic treble damages, no judicial discretion involved, and a pretty open shot at an attorney fee award for a prevailing plaintiff. It's only in recent years that the scope has retrenched any at all.
So both Matt and Alicia, you guys have raised some really interesting distinctions and differences across UDAP statutes and with the federal laws. Why should I not bring all of my claims in North Carolina?
Well, of course, there might be extraterritoriality problems. As welcome as you would be here, Christina, let me hesitate to say, and by the way, if you're looking for North Carolina counsel to help you with that matter, I'd be your way. But as welcome as you would be if you had an Alaska client that was suing an Alaska defendant over an Alaska fact pattern, you would have significant extraterritoriality problems in bringing that claim. I mean, you point out two problems. There's a layer of Commerce Clause sort of analysis and or just sort of state equivalence of Commerce Clause analysis to try to decide how far a given state statute can reach. And also, of course, there's a significant layer of choice of law, horizontal choice of law, state X versus state Y, that courts sometimes forget to apply at the beginning of these cases. It's interesting, I read a case pretty recently where a claim was pleaded under the law of only one state. The court engaged in choice of law analysis, decided that the operative state law was the law of a different state, and just dismissed the first state's claim, the claim under state one law, outright. Didn't say the Wyoming analog is X, let's now apply the Wyoming analog. Said you pleaded it under the law of Alabama. Alabama law doesn't apply as a matter of choice of law analysis. Game over as far as the UDAP claim is concerned. This all sort of rears its head when you get these multi-state class actions that often get collected in MDLs, that courts' familiarity with choice of law principles really gets tested, especially where, frankly, you've got in an MDL situation, one court, wherever the MDL is collected, that is challenged even in deciding what choice of law regime to apply, and then to apply that regime and to choose the law accurately as to how the plaintiff pleaded things. So as welcome as you would be here, you might find some obstacles, but come down for a Duke basketball game instead. We'll have you for that.
What trends do you see in the efforts at the legislative level either to expand or contract the scope of state UDAP laws?
So let's talk about substance, and then let's talk about the lawyering aspects. One thing that's substantively become a push in some state legislatures is to work on the interplay between UDAP statutes and other fields of law, like securities law, like utilities regulation, and the like. A number of bills have gotten traction to say that if the state antitrust laws apply, the UDAP statute categorically doesn't apply. Or if this relates to utilities conduct, that's what we have utilities regulation for. Almost a variation on the theme of the state action doctrine, where we've got one sphere of regulatory approach, and we're not going to let that extend into something else. Procedurally, one hot topic has to do with attorney general enforcement. The attorneys general are very often among the primary enforcers of these statutes, at least the primary governmental enforcers. And it's been a trend in recent years in some states for attorneys general to retain private class action counsel and to almost subcontract the pursuit of some of these UDAP claims. That has drawn the ire of defendants, unsurprisingly, but also some state legislatures. And there's been some amount of legislation to regulate or outright prohibit the retention of contingent fee class action firms. Likewise, something that's played out, for example, in the opioid litigation, is UDAP litigation by sub-state entities. That is to say, local governments, county governments, etc. Very often, of course, these have got very small law offices, if any, nothing like an AG's office. So they are pretty uniformly getting approached by and are retaining private class action counsel. And there have been a number of situations, quite recently, where those local government litigants are essentially trying to litigate in competition with their own attorneys general, and leads to interesting questions about whose right of action it is, standing-like concepts. Also interesting questions of authority to control litigation as a matter of state law, which often is a pretty murky question under the law of a given state as a matter of sort of vertical separation of powers, home rule, and that sort of thing within the contours of a given state. Those are examples of how right to litigate and right of action definition and other procedural points end up becoming the battlefield because the substantive issues are so wide open.
Now, you mentioned the involvement of the state attorneys general in enforcing their consumer protection laws. I mentioned that you had recently served a term as your state's solicitor general. And for those listening who might not quite understand the difference between the solicitor general and the attorney general of one of the United States, can you just explain a little bit about what the solicitor general's role is in state government?
State solicitors general have existed for the most part for only 30 or so years. And the definition of a solicitor general is typically the chief appellate lawyer for a state, analogous to the role of the Solicitor General of the United States, who is the chief appellate lawyer for the United States, especially in the U.S. Supreme Court. Typically, the SG of a state is the designated lawyer for that state in the U.S. Supreme Court, and often that person will oversee appellate litigation in general. Almost always will oversee most of the civil appellate litigation and sometimes criminal appellate litigation as well. That person is not typically an elected official. Often she will be an appointee of the Attorney General. Usually that person is a high-ranking lawyer in the Attorney General's office and a person who's part of the so-called front office, part of the close group of advisors to the Attorney General herself.
So you came to the job then with a background in antitrust, commercial disputes and business-related appeals. What were the notable cases that you worked on?
Pretty often, the consumer cases in an attorney general's office or even the competition cases are pretty well staffed by experienced competition law lawyers and consumer lawyers. And so many of those cases end up settling that relatively few of them end up on the docket of a solicitor general, whereas a state SG very often finds himself embroiled in a lot of the constitutional litigation. And that was the case for me, which is a lot of fun, certainly. I got to argue a case in the U.S. Supreme Court about the territorial limits on state taxation of trust income, involving some points of law that I knew very well and some that I didn't know at all. Got to educate myself about that. Got to litigate the tail end of an interesting dispute about state property ownership, specifically the property ownership of a riverbed, and whether that question is a question of federal or state law for purposes of federal question jurisdiction. And then we had a big piece of litigation in North Carolina in 2018 over the legality of ballot measures related to state constitutional amendments. And it was an interesting situation because normally the state AG and the Solicitor General are the defenders against challenges to state law. But in this case, we were actually in the plaintiff's position, that we were an initial defendant in the case, one of several, the Attorney General was and the Governor was, and ended up cross-claiming against other defendants to question the validity of ballot measures that were offered in several areas.
So, Matt, you've obviously had a very storied and extensive career, both in private practice and public practice. I think our listenership be very interested in your answer to a question we ask all of our guests. But if you have any advice for young lawyers who are looking to do what you do.
I've been around a while, been in practice about 31 years, and I was really fortunate coming up in practice to have senior lawyers in my firm give me a lot of advice, and it's always served me well. One of the things they told me from the very beginning is your reputation is indelible, that everything you do in practice leaves a trail, and you want to leave a good trail so that your good deeds will multiply in your reputation in the profession, and that is definitely true. The other thing about private practice that I think is important for younger lawyers to be aware of is the lifeblood of any private firm is tomorrow's clients, whether it be continuing relationships with today's clients because of good service that they receive and good value that they receive, or a set of relationships and reputation that cause incoming phone calls from new clients. Either way, from your very first day in practice, you want to think about how you're going to be able to contribute to those processes. And that's not as hard as it might seem or as daunting as it might seem for younger lawyers. Keep in touch with people from your law school class. Consider every lawyer you work with, whether on the side of the V or across the V. Consider that person a potential friend and a potential referrer and a person you can, offer help to and value to. That, all of those little deposits of good conduct and help and just living the right way, all those things add up, and the day will come when they'll kind of reach critical mass and your phone will ring. But like every other kind of a savings program, you got to start early, get that compounding process going from the very beginning. And where that really starts is just being conscious of it.
And I think those are honestly two sides of the same coin in terms of ensuring that your reputation continues to be what it is from day one of your career to, whatever end of your career may be, and how that does feed into ultimate client development. Another question we like to ask all of our guests is to tell us something interesting about yourself that we wouldn't know about you if we only knew you professionally?
Probably the most surprising feature for me might be that I'm an opera singer. I've been a singer almost my whole life, since middle school anyway. And in the last several years, I've been strengthening my voice by taking voice lessons. And when I started, my teacher said almost immediately, for what you want to achieve, you need to sing opera. So I am part of the North Carolina Opera Company. I also sing with the resident chorus of the North Carolina Symphony, which is called the North Carolina Master Chorale. Undermining what I said about reputation, you can actually find a number of photos of me in various strange outfits from operas I've sung in. So I'll let people go searching for those.
Well, Matt, really appreciate your time today. And, I feel like we've learned a lot about you personally, your career, and a lot more about UDAP statutes. Before we go, however, we do have our final segment, The Curious Hat.
And now it's time for The Curious Hat!
So, Matt, if I can ask you to pick a number 1 through 25.
I'll take 3. My son's lacrosse number was 3, so I've had time to think this through in advance.
Okay, number 3. What is your favorite vacation destination?
Probably Prague. Some years ago, my wife and I took a vacation together to Prague, stayed at the King's Court Hotel, which I recommend very much. And I always like to tell the story that we found the pillows a little on the soft side and called down to the front desk. And they immediately sent up not one, but 2 different sort of Soviet-era chambermaids to give us buckwheat pillows. They were very supportive. I don't think I've ever experienced such firm pillows, but it was a wonderful experience. Great city, charming city. Recommend it very much. Happy memories. They always say the places to have a beer there. If the beer is less expensive than the water, that's the place you want to be drinking.
I thought you were going to say Oktoberfest would be the time to go there, but summer is just as good. It's Oktoberfest there all the time. So Matt, thank you again for joining us today on Our Curious Amalgam, and to our listenership, thanks for listening in.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.